Welcome to a live episode of Surviving the Survivor. We bring you the best guests in all of true crime. Don't forget to subscribe and smash that like button. Here's your host, Emmy Award-winning broadcaster, Joel Waldman.
No trial will occur. Thus, there is no need to preserve Mr. Kohberger's right to a fair trial because he has already admitted guilt. That is the fiery argument coming from not one, not two, not three, but 24 major media organizations. They include the New York Times, CNN, ABC, the Idaho Statesman, the Idaho Argonaut, which is the student-run newspaper at the University of Idaho, as they make this final push to lift the gag order in the Bryan Kohberger case. Welcome to Surviving the Survivor. This is the show that brings you the very best guests in all of true crime, and we bring you live breaking news when it happens and court hearings. And today is another big one ahead of next week's sentencing hearing in Boise, Idaho. I will be there. STS will be there, and we will bring that to you live. And we're trying to work on a couple of cool things while we're out there, in addition to just the sentencing hearing. So, hello to everybody at STS. We're going to be taking you live to this critical court hearing from Boise, Idaho. It'll be, I believe, in the same courtroom where Judge Stephen Hippler has been presiding over this case. He is going to hear arguments primarily via Zoom, I believe, on whether to vacate what is known as the non-dissemination order. That is otherwise known as the gag order that has kept this case under such a tight lid. And if you'll recall, back on May 9th, Dateline NBC, they ran a piece that had a lot of information that was believed to be under seal, and Judge Hippler was not pleased about that. There was debate about whether it was right for NBC to release that. They're the media entity. Reporters are going to report. That's what they did. The real issue Judge Hippler seemed to have was with the government and or the defense, whoever was leaking that information. And the thought was that it was the government, and he even stated at the time that he was looking to start his own independent investigation. And if need be, he was going to take the cell phone devices and other devices of people working the case to try to, figure all that out and see who was possibly responsible. We're joined now by Erin Tognetti, a former prosecutor and defense attorney out of Pocatello, Idaho. Erin, good to see you. How are you?
I'm good. How are you?
Good. So this is really a battle over the First Amendment here. We've got Bryan Kohberger saying on 4 separate occasions, I'm guilty. I killed this person, meaning Kaylee Gonzalez, Xana Kernodle, Ethan Chapin, and Maddie Mogan. He admitted to the murders of all 4 of them. And now the media is saying, show us the money, basically. Give us all the evidence, unseal everything. So what should we expect at this hearing? By the way, it's being streamed by the Ada County Courthouse, and we'll put that up the moment it begins. But Erin, what should we expect today?
Well, I think it's interesting. I did go and read the motion by the media to lift it. And, apparently at the change of plea, the state had asked to keep that non-dissemination in place just because they kind of knew, I think that the prosecutors knew they would be flooded with requests for statements and interviews and things like that. So they asked to keep it in place. And the media, the motion made by this conglomerate of different various media outlets is basically saying, well, there's no good cause anymore for it, because the reason for the non-dissemination order was to make sure that Bryan Kohberger, gets this fair trial. And what their argument is we're well past that. He's already entered a plea. What I would say is that I think, if I was the judge in that, I would have some concern just because there is a motion to withdraw a guilty plea. I mean, you have to have a good reason for it. It's not, they don't do it arbitrarily. And a lot of times it's rarely granted. And even when they appeal the issue of, well, the court wouldn't allow me to withdraw my guilty plea, a lot of times that's been upheld. So if you're actually looking at the actual case law that would be binding on this, it's a long shot. But at the same time, we're only 1 week away from sentencing. And so I could see the judge saying, okay, well, this is granted, but I'm going to stay execution of this order, lifting the non-dissemination until after the sentencing. I could see him do that just because this is so high profile. You don't want anything to go sideways. And people do. I've had cases where all of a sudden we think the whole deal is done. And then all of a sudden a defendant says, I want to withdraw my guilty plea. I want my trial. My attorney didn't advise me properly. And so it can happen.
Can he do that up until sentencing? Can Bryan Kohberger say to the judge or to his attorneys, I want to withdraw this this plea deal I just made. I want to go to trial. He has until when to do that?
Well, I mean, you can technically make that, you know, I mean, if you actually were looking at case law, you would see that there are people who, you know, take the deal, go through sentencing, get probation, screw up on probation, and get their sentence gets imposed, and then they say, whoa, 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 I want to withdraw my guilty plea. So I mean, you can do it post-sentencing, but when you do it pre-sentencing, the odds are slightly better of it maybe being granted. Post-sentencing, it looks a lot more like gamesmanship, right? Where, well, you thought you were going to get probation, and instead the judge is sending you to prison, and now you don't want the deal. You know, so you'll see that, but it's always possible. I'm not saying it would have a high likelihood of success, but as a judge, why not give it one more week, you know, to get past sentencing?
And by the way, so that is really what we're talking about here, because it sounds like once sentencing is done, which is next Wednesday, I believe, July 23rd, and we will be out there for sentencing. Once that's over, I believe the gag order will be lifted. So this is really just the scope of this is really just this week here between now and when sentencing is. You know, the media, they're hungry, they're thirsty, they want to get these stories out there. So they're looking to have this done as quickly as possible. But there's a chance that Hippler, probably a good chance that Hippler, because of what you just said, hey, this could still go sideways. Let's just all hang tight. And the gag order will be lifted once he is formally sentenced next week. Is that what we're talking about in terms of a window of time?
Yeah, I mean, he could, you know, and like I say, so they can make that motion, you know, but that's, if you remember from the change of plea, that's why the judge so painstakingly goes through all of those questions, right? And he has to, because then he can't say, well, my attorney didn't tell me I was going to spend the rest of my life in prison, but the judge can say, well, that's vitiated because I told you. During your change of plea, I told you that this is what you were looking at, that there was the potential for you to spend the rest of your life in prison. And so that's why they go through that. So while the likelihood is low, for me, I'm a little bit surprised, because I think that the judge at sentencing, as soon as sentencing was done, the gag order, you know, this non-dissemination likely would have been dropped at that point anyway, because it's a done deal. So I'm a little bit surprised that they went through all of this effort. I mean, the judge still, because that non-dissemination order is in place, he still has to lift the order, even at sentencing. You know, he would still have to lift that order. But when you're a week out, I guess I was a little bit surprised by the media going through all of this exercise right now.
Yeah, Miss Behaven here says more of a chance of me swimming the English Channel. Don't do that. They've got strong currents. Than BK withdrawing his plea. This, by the way, was supposed to start 5 minutes ago. They're on Mountain Time in this part of Idaho. Idaho has two time zones, but it is 10:30 in the morning Idaho time. It's now 10:35 out here in Miami. 12:35. Are you on Mountain or are you on Pacific time in Pocatello?
Mountain time. Ironically, it's just the Panhandle that falls into Pacific. The rest of, so even Boise's in Mountain time.
Okay. So let me just go through some of this. Again, there's 24 media outlets, and obviously COE and Spacey bring that up the second we see it, but there are 24 media outlets: CNN, Fox News, ABC, the New York Times, Idaho Statesman, which is Kevin Fixler, who is the investigative reporter. And he has a new piece out today, by the way. He's doing these extensive profile pieces. So he has one out today about Ann Taylor. They all jointly, and I'm not sure, to be honest, how that even works, all these different media outlets, but they jointly filed this motion to vacate the gag order. And they say in their motion, it is, quote, moot and unconstitutional to keep the gag order. Here's a longer quote. It reads, there is no possible set of circumstances under which Mr. Kohberger will ever face a jury. No trial will occur. Thus, there is no need to preserve his right to a fair trial because he has already admitted guilt. Thank you, COE. So yes and no, because Erin, it's the point you just made. Defendants can be fickle, especially this guy who appears to be a control freak. And he could pull the rug out from everyone and say to the judge or whomever, hey, whatever I said last week, I didn't really mean it. Let's go to trial. By the way, Erin, I don't even know if you know the answer to this. Worst case scenario. Let's say that happened. Would his admission of guilt be allowed in a trial now? If he was to say, I want to go to trial after admitting guilt?
And you can't just withdraw a guilty plea. There has to be a basis for it, right?
Okay.
So they would have to have some reasoning. What I'm saying is I've been surprised over and over again by things that happen during these types of criminal trials. You know, never think that you're going to be surprised. Something's always going to happen that's unexpected. And in the course of this, there's a lot that we don't know about his communication with really anybody. We don't know who he's communicating with. We don't know what his communication with Ann Taylor is. So is there some set of circumstances where he could bring this motion? And if it really was under duress, right? Say somebody's threatening him, and he didn't tell anybody, but they were threatening to kill my mom, right? We just don't know. But so say something, and I mean, jail calls are recorded, like the odds, I'm just saying, right? I'm just trying to give any set of facts that might support this. If he did it under duress or was having some kind of mental breakdown that then a doctor said, yeah, he completely lost his crackers and thought he was an alien last week when he entered his plea, right? If there were any set of circumstances that would support it to where it wasn't a valid plea, then the court would more than likely exclude it from trial as being overly prejudicial because there isn't a basis for it. So if he wanted to withdraw on some set of facts that were sufficient for the court to say, okay, well, that was not a good plea, then he's not going to allow it at trial because it doesn't have the right, it's not substantiated, if that makes sense.
Yeah, and this is a case that seems to always have like another layer of, what ifism, like what if this happens, what if that happens. The judge, MB, is saying in the chat, specifically said it could be used against him. Here we go.
On the record in State v. Kohberger, CR 0124-3166.
Judge Stephen Hippler presiding. We'll watch and then we'll talk after.
By video is the defendant in custody with counsel, Ms. Taylor, Ms. Barlow, and Ms. Massoth. State is represented by Mr. Thompson, Mr. Hurwitz, and Ms. Jennings. On behalf of the media petitioners, we have Ms. Olson and Mr. Pedersen. Today's hearing is to discuss the media's request to terminate the non-dissemination order. The state filed a response indicating it was no longer objecting to that, and the defense did file an objection indicating that they do have a continued objection to lifting the non-dissemination order. I've read the briefs that have been provided by the parties, and I'm going to attempt to shortcut things here a little bit by asking whether the defense, who is the objecting party, has anything additional to add beyond what it had in its briefing before. I don't know that I need to hear from, frankly, the petitioner. I think the briefing was adequate, so let me just start with Ms. Taylor to see if there's anything else she wants to add.
Your Honor, there is not, but if there's further argument, Ms. Barlow will be making that argument on behalf of the defense.
All right. And to be fair, Ms. Olson, was there anything you felt was important to add that was not contained within your briefing?
Your Honor, we would just briefly say in response to the defendant's brief, we certainly understand the expressed concern about the media coverage of their client. We don't think continuing the non-dissemination order helps that at all. It simply continues to limit the ability of the members of the press to reach out to the people who know the most about the case. It doesn't obligate them to say anything. We also understand that they expressed that there was a due process right related to the sentencing. I read the case that they submitted. I think that there is obviously a due process right at sentencing, but I don't think that case is really it doesn't provide any guidance to the court here, because that was about information provided to the court. And given the very limited scope, and we understand it's very important, but given the very limited scope of what's to be decided at the sentencing, we don't think the arguments that Mr. Kohberger made should outweigh at this stage the First Amendment rights of our clients. Thank you, Your Honor.
Thank you. All right, in light of that response by the media outlets or interested outlets, Ms. Barlow, do you want to add anything?
I would only say, Your Honor, as this court is well aware, the publicity in this case is so extensive and emotions are already so high that adding fuel to the fire of media interviews or a rush to interview people as they leave the courthouse or enter the courthouse would only increase the concerns that the defense has. And even though the plea has a specific sentence attached to it, as this court is well aware, things happen in plea hearings and, sentencing hearings. And to minimize the possibility of that, we request that this order stay in place.
All right, thank you. All right, as the court has considered the petition, frankly, the court was prepared at the time the plea was entered to lift the non-dissemination order in order to give the parties time to evaluate that and to ensure I wasn't missing anything. When both sides objected, I agreed to continue the non-dissemination order. I also indicated that I would have the potential to look at that again before sentencing, because frankly, I anticipated the motion from somebody, in this case, the Ms. Olson and her clients, was likely to be coming. At this point, I do not believe the purpose of the non-dissemination order, the primary purpose, which is to ensure that we can seat a impartial jury, is any longer at play. The concerns identified by the defendant, while certainly not to minimize those, they are concerns and they are significant concerns. I do not think, however, the non-dissemination order and the right of the public to information is outweighed or outweighs those rights, I should say. And frankly, I don't think that lifting the non-dissemination order will meaningfully impact those concerns. I mean, the media frenzy, as it has been described, will continue regardless. It is a little bit like water will find low ground. In this case, the media is going to write about something regardless about this case. The lifting the non-dissemination order does not require the counsel or others who were previously bound by it to speak. And the state has indicated they don't intend to until after the sentencing. And certainly I would hope that the media interests would respect those positions and give people the space that they need and request. In terms of, for example, the defendant's family and others coming and going at the sentencing, we intend to have, as we did before, appropriate security measures in place to ensure that they, as well as the victims, are allowed to get in and out unscathed by the media if that's what they wish to do, or if they wish to speak to the media, they can do that as well. At this point, I just don't think that I can justify the continuation of the non-dissemination order. I think the rights of the public to information in this case is paramount, given the fact that a plea has been entered in this case, and so I'm going to lift the non-dissemination order. But I want to point out what that means and what it doesn't mean. So obviously, nobody's required to speak to the media, first of all. Second of all, I want to be clear that the court's prior preservation order to the parties is not lifted and continues to stay in place. And so it's important to understand that those obligations still exist. And then the other thing I want to point out is that by lifting the non-dissemination order, that does not convert sealed documents to unsealed documents. Documents previously sealed by the court are still sealed. Now, I see the media also filed a petition to be heard to unseal everything. I'm denying that outright, the request to intervene, because I think it's premature at this point. So the court will its intent is to, after sentencing, begin the process of reviewing all the sealed material in this case to determine what should be unsealed and what should not be unsealed. That process will include an opportunity for counsel to register any objections to unsealing documents, specific documents, and request to redact certain sealed documents before they are unsealed, or unseal them in a redacted form. I intend to do that in groupings of documents at a time. As I sit here now, my thought is I'm going to start from newest to oldest because those are the ones that I have the most working knowledge of as to the reason for the sealing of the documents, as well as the content of those documents. And so I think I can get through those more quickly. As we move backward in time, it's going to take further, more extensive review by the court to figure out, to obviously review the content of those documents, listen to those hearings, et cetera, and determine why they were sealed and whether that rationale still is necessary, or that rationale still requires the documents to maintain that sealed status. And so before everybody gets out their pen and paper and sends in public records requests, understand those will be denied for sealed records until they are unsealed. And that process is going to take time. And I'm not talking days. I'm probably not talking weeks for that to be accomplished. So I hope people understand patience will be required to get through that, as I'm going to have to review those myself to make those decisions. Now, we may be able to speed things up if neither party objects to groupings of documents or specific documents being unsealed. But it's important to review those because those documents may include information that, pursuant to Rule 32, are not to be made public, including birth dates, social securities, information about minors and victims, and information that would be essentially inappropriate to unseal, including protection of individuals from undue harassment, et cetera. And so that's just going to take time. In addition, I'm unlikely to unseal much until after sentencing and after the appeals period has run. Now, I recognize the plea agreement includes a waiver of the right to appeal, but as the parties probably know, the U.S. Supreme Court in Garza versus Idaho has indicated the fact that a defendant waives the right to appeal doesn't mean they don't have the right to appeal. And so it may affect the outcome of that appeal, and it may affect the underlying case and the plea agreement. But nonetheless, the right to appeal does not go away because of the waiver. And so I think it's important for that time period to also play itself out to see that it goes the way that I think people intend and expect it to. And so I will be entering an order in the next week or so outlining the process for the review of the sealed records. And counsel will need to maintain a presence in the case in order to review those materials as they are proposed to be unsealed by the court. Because the timeline that I will likely give you will not be, I suspect, extensive as for each group of records. So I might give you 14 days, for example, to provide a response as to a group of, a dozen or a couple dozen records at a time. So just sort of heads up and fair play with respect to that. Any questions by the parties about the ruling today?
Not from the state, Your Honor. Thank you.
No questions from the defense. Thank you.
Ms. Olson, do you have any questions?
And I don't, Your Honor. I wasn't certain if I was included within the parties. I would just say I think that the court's proposed manner of moving forward on the sealed records will likely largely address our interests, and we appreciate the court setting that out in this hearing today.
Yeah. If certain records after review maintain their sealed status, it would be at that point that I would entertain requests for me to consider that more formally and to have a voice in that. But I think until I've gone through that process, it's premature, which is why I don't intend to take up your motion, your more recent filed motion at this time. So,
thank you, Your Honor. We appreciate that.
All right. And with that, then we are adjourned. Thank you. I'll see you next week.
Thank you, Your Honor.
There you have it. That was about a 13-minute long hearing. And the headline here is Judge Stephen Hippler, who is presiding over the case of Bryan Kohberger versus the state of Idaho. He has now lifted the gag order, otherwise known as the non-dissemination order. He has lifted it, but files that were sealed previously remain sealed. You're looking at a shot that the COE was able to capture. That was Bryan Kohberger in his confines at the Ada County Jail. You can see there's not a whole lot of paintings on the wall there, and he's in what appears to be a form of a prison jumpsuit, the maroon color. So people were saying he was wearing civilian clothing. I believe that is jail clothing, and he's got that real creepy stare once again, looking at the monitor. It appears, those eyes wide open. But Erin, any surprise here? Were you expecting this outcome? And then we'll get into some of the details of what Judge Stephen Hippler laid out just now.
I'm a little surprised, like I say, just because there is there's a little bit of uncertainty for the next week. Like I say, it's I can't imagine a scenario, but there again, sometimes you're just surprised in these things. But he clearly thinks that the basis for it, which is the a fair trial for Kohberger, is just no longer a good enough basis for it. There will be sealed documents. I don't know. I haven't seen a list of exactly what exhibits, what evidence in this has been sealed to date. Usually that's the stuff that's going to provide, personal information. Like you said, whatever they have that they'll be releasing afterward, part of it'll be redacted just because you can't release birth dates, social security numbers. We also need to consider that the breadth of this investigation, we don't even know. I mean, for all we know, the police interviewed 100 people. Well, there may be identities, I saw somebody put in the chat something about the alternative perpetrator theory, and those people, and there was never any substantiated evidence. So there's no reason to put those people's identities out there where they could be subjected to potential harassment. So, things like that I could see will remain sealed, and then other stuff will be redacted to take out certain personal information, things like that. But what this means really, and like you said, nobody has to talk. What this means is that now you can. And so, that'll go for law enforcement, for the investigators and stuff like that. They've been under the gag order as well, to where they're not supposed to talk about the investigation. So now they will be able to, Ann Taylor, if she wants to. The state has seemed to already say that they will not, be talking to anybody before sentencing. But that kind of goes to what I was talking about before, that, what if there are some strange set of facts that we don't know that could come in and shock everybody with a motion to withdraw his guilty plea? And odds for that will go down after sentencing. So.
Yeah. John Nolan here, better not be able to appeal. I thought he waived that right. Let's dig into that. That was one of the last things Judge Hippler said. This is what makes America great and crazy, is that the worst of the worst have their rights. And he cited case law, specifically Garza versus Idaho. Judge Stephen Hippler did. And he said that in that case, they determined that waiving your right to appeal, which Bryan Kohberger did, doesn't mean you don't have the right to appeal, which is counterintuitive. Doesn't sound like it makes sense. But Erin, and I know you're not a legal scholar, but in so many words, the way I understand it, even if you're the defendant and you say, yeah, I waive my right to appeal, I don't know if it's an automatic appeal, but somewhere there is wiggle room for him to still appeal what he agreed to.
Well, and I haven't read the Garza case. In fact, I was just pulling it up. I had it pulled up because the judge said that, and I haven't read that. But I think that what that means, and I would tell everybody, because I know everybody kind of lost their minds there when the judge said that. Keep in mind, this will be a very, very high bar. And I haven't read Garza, I need to, but what I suspect is that it's one of those situations similar to what I was saying about withdrawing his guilty plea, is that if there were some set of circumstances when he waived that right, whether he was incompetent, whether he was doing it under duress, I think it would have to be at that level, one of those kind of things, for them to say, well, he didn't voluntarily waive his right to appeal. Right. And so that's why when he goes through the change of plea and all of that, it's very, very careful. Are you in a good state of mind? Do you have any mental illnesses? Have you had any alcohol or mind altering substances? Is anybody forcing you to do this today? Well, if somebody came back later and said, I was forced, and there was any actual basis for it, then there could be grounds to say, well, he didn't voluntarily waive his right to appeal. I don't see that happening in any way, shape, or form. I'm just saying that's why there's always this caveat out there, that things happen. I don't think it's going to happen in this case. So I think that, there won't be any of those grounds. And even if he ever tried to bring something like that forward, it would be such a high bar. They are not going to let him wiggle out of this easily. And it would have to be something so substantiated, like I said, like 4 doctors coming in and saying he was having some kind of psychotic break and was talking about how he thought he was from Mars. It would be something extreme. So I don't see that happening, but there's always a tiny caveat possible under the right set of circumstances.
Yeah, and if you're just joining us, this is Surviving the Survivor. We do a live true crime panel show every night of the week, but we are following the latest Bryan Kohberger hearing. Judge Stephen Hippler has lifted the gag order, the non-dissemination order. He made it clear, however, that sealed documents in this case are going to remain sealed. He literally has to go through every one of those one by one and make his own determination. And he said it could take months to get through all that. So he warned everybody. We are joined by the great, the one and only Skye Lazaro. Skye, first and most obvious question, are you surprised at all that Judge Hippler lifted the gag order here? The defense now, they filed a motion late last night. They did not want it released. And the primary reason, really, one of them was they don't want, and I'm paraphrasing here, but they don't want Bryan Kohberger's family being harassed. And even the judge, that kind of irked me. I got to say, Judge Hippler, with all due respect, he put the defendant's family ahead of the victim's family, saying that he had concerns about the media basically racing to speak to the defendant's family and not, not physically attacking them, but verbally trying to get at them as they go in and out of the courthouse. Was that a misstep, by the way, by the judge to put the defendant's family ahead of the victim's family? And that's why the defense, I think, says, no, you should not have lifted it, but the judge has now lifted it.
Gag orders are interesting, I think, in a lot of respects, from the standpoint of court proceedings are supposed to be open and public proceedings for the most part, so that, everyone can, observe and partake in them, and people have a right to a public trial. I do have a reserve seat this week. You're right. You guys are probably smart at looking at my face. I think the reason for the gag order in this case initially was to preserve the integrity of the trial. Where we're not having a trial, I do think there is probably an argument that the gag order is no longer necessary for the same reasons. That being said, I don't know that you necessarily want people out talking about it, although he has entered a guilty plea at this point. All that's left to be done is sentencing. With respect to putting the defendant's family before the victim's family, I think it's probably a poor choice of words. I mean, certainly I don't think his family should be, accosted by anyone or subject to that. They didn't commit these crimes. Mr. Kohberger committed these crimes. But I think in this case, where the victim's family has come out pretty publicly and not very supportive of this plea, or at least initially, I think the timing, and I think probably the way you phrased it, and I didn't see the exact phrasing of it because I was in court and I'm just joining, probably was a poor choice of words. But I mean, candidly, this judge has kind of continued to do that throughout this entire case.
Yeah. I'm wondering, do you have something, and I don't know if you know all the case law, but he cited Garza versus Idaho at the very end, which basically says, a state Supreme Court case, I think, which says that even though a defendant waives his right to appeal, which is what Bryan Kohberger did, it doesn't mean you don't have the right to appeal. Do you know if a similar, law exists in Utah, where you go in front of the judge and you waive your right to appeal, but you still have the opportunity to appeal?
You do. So when you enter a guilty plea, you essentially waive appellate rights that would have come from having a trial. So he's waived his right to appeal, challenging, mostly waived his right to appeal, challenging like pretrial rulings that the court made. But he does still have rights to appeal as it relates to, his plea being knowingly involuntary, or any post-conviction relief act type remedies, potentially. Also, he still has a right to appeal the sentence. So there are limited rights of appeal, and I'm not real familiar with that Idaho case, but I think, the United States Supreme Court has some guiding case law on it that all states essentially have, and that language is included in our plea agreements here in Utah as well, that you're waiving appellate rights that you would have had if you had gone to trial and had a trial, but you still have appellate rights as it relates to, your sentence, and then also the entry of your plea.
Yeah. Brooke Blondale here. Kohberger's family could be in danger, even though they haven't done anything wrong. The victims' families have public support. That is likely true. Even the judge, could potentially be, God forbid, in some sort of danger. He has to take precautions on a case like this with this much publicity. The basis of Garza, according to Ali, was ineffective counsel based on his attorney who didn't file the appeal on time. So that is where you get that from. But let's break this down. Again, it was only a 13-minute hearing, and really it was essentially 24 media outlets, including the New York Times and Idaho Statesman, and then you had both sides, the prosecution and the defense from this case, who were all present, including Bryan Kohberger. There's a debate going on whether or not this is a jail-issued jumpsuit sweatshirt, which to me it appears to be, but I don't know. We'll get word. Someone will have the answer to that definitively. But Judge Stephen Hippler came out and basically said, yeah, this is a hearing about lifting the gag order. And he says the state does not have any objection at this point, but the defense has continued objection. They filed a motion late last night saying, please don't do this. And then he went on to say, well, look, I've read the brief, so I'm just going to sit here and ask a couple of questions. I'm not going to go over everything point by point. One of the attorneys said, publicity in this case is so extensive, the emotions are so high that they don't want to add fuel to the fire. It would only increase the concern the defense has. And that's prior to him saying he was lifting the order. This is the argument they were making, that they wanted to minimize the dangers and keep the order and the stay in place. Erin, is that really the issue here? Are they really concerned about, quote unquote, adding fuel to the fire? Are they really concerned about safety here, the safety of maybe Bryan Kohberger's family, the judge, other people? Or is there something underlying? Is there another reason that the defense doesn't want this gag order lifted? And again, Hippler said, the judge, that he was going to lift this anyway, and it would be lifted no matter what after the sentencing. So we're only talking a matter of a few days here because the sentencing is Wednesday. But back to my question, is it really an issue of safety, or could there be something else at play that the defense is trying to keep, out of the public's eye?
Well, I think we know enough about the case, right? There's so much we don't know because it didn't go to trial. We didn't get to sit there and watch the presentation of all of this evidence, right? They had a lot of evidence. They thought this trial was going to go for months. So there is a lot of evidence that we don't know about, that we just haven't seen. So we know so little. So by lifting this gag order, I mean, if I was on the defense side of this, I mean, we all know he's a monster, and he's just done something that's so horrific. And every new detail that comes out about this is going to make him worse. Mm-hmm. And so I think based on that, the more information we get about this, if there are actual photographs of the victims, things like that, if there's, pictures of the blood, if there's pictures of the crime scene, things like that, people who hated him before and maybe hate his family because they think maybe they knew things, are going to hate them, are going to just hate him that much worse. It's sort of like when we were on and we were talking about what the Gonzalez family said about her fighting back, and does that, and you said, does that make it worse? Right? We have what I see as probably just an absolute avalanche of things that are going to make this worse. So from a defense perspective, if you already know your client's going away forever, do you really want the stigma around him and maybe around his family and maybe anybody who was ever friends with him, to know the full level of what a monster he really is and how horrific the scene was and the actual injuries, things like that. So I think that he is correct in that this is going to add fuel to the fire. The problem is that it's 1 week, and then it was going to be out there anyway. And then he's going to start unsealing stuff. And so over the next few months, the media is going to have more and more details on this. And there's no way to soften the blow on how horrific this was. It's just going to get worse from here on out.
Yeah, and go ahead, Skye.
I was going to say, I will say, I don't know if Idaho has similar statutes, but we have, as it relates to attorneys and things that were provided in discovery, even documents that aren't necessarily sealed, some of those are still protected from dissemination without court order, which are not necessarily anything that you could get pursuant to some sort of GRAMA or public records request. Those things aren't going to be sealed no matter what, but there are certain things that we can't ever disseminate even after the case is closed. Obviously, if he appeals or files some sort of post-conviction type filing, those things may become part of that record. But in terms of crime scene photographs, things like that, we as attorneys are not allowed to disseminate those things just under our local rules.
Yeah. I'm going to be heading out to Boise on Monday. I get in the afternoon. That night, Monday night, I've got a roundtable set up with just private citizens from the city of Moscow and Pullman, which is where Kohberger was doing his PhD. Just their reaction, because they live this every day in those two communities. So we're going to do that Monday, and then obviously Wednesday I'll be at the sentencing hearing, trying to work on something very interesting for Tuesday, which I'll let you know if I can figure it out. Julie Frew here, letting us know. She's our mod that keeps us all together. He's a K-10 in jail, in a jail or prison setting. K-10 status, often referred to as keep away, indicates that an inmate is classified as requiring administrative segregation from the general pop. He is going to have any horrific prison movie that you've ever seen. It's going to be a lot worse for him, especially the first weeks and months. I think this guy's life is going to be absolute torture. He's not going to be able to leave that cell, because there are going to be people salivating to get after him. Again, if you're just joining, the gag order has been lifted. That means that the media can sort of have at it, but the judge made it very clear only if the participants, let's say they're going to the defense or the government for questions, only if they agree to speak. No one has to speak. Also, documents that were sealed are going to remain sealed until Judge Stephen Hippler literally goes through them one by one to identify what can be unsealed, if parts have to stay redacted. He was talking about things like birth dates, social security numbers, minor children. None of that stuff can be released publicly. So he literally has to look at all that one by one. But Skye Lazaro, he said, at this point, he said the primary purpose of the gag order was to seat an impartial jury, but that is no longer in play. And he said that lifting the gag order is not going to stop the media frenzy, or not lifting it. So whether you lift it or not, you're still going to have a gag order. But really, he went back to the fact that he had it in place to seat an impartial jury. Now you don't need an impartial jury, and that was the reason he said, okay, I'm going to lift it. Is that what you expected in terms of the rationale, the reasoning from the judge?
That makes sense to me. I think I would expect that if that's the purpose for the gag order, it is no longer needed. There's still, rules of professional conduct with regard to commenting, and gag orders really, they don't stop the public. They don't stop the media frenzy at all. I think every media case is, evidence of that. Gag orders, judges only have authority over the people in the court. So the attorneys, maybe potential witnesses, people who work for the court, perhaps, the state, the defendant. But the gag order isn't, the court doesn't have authority over the general public and what the general public wants to say about it. And so, if you're just trying to limit what attorneys can comment about in the public prior to trial, which is a primary reason we see these entered in cases with a lot of publicity, then, I think the judge is correct in that it's no longer necessary. That doesn't mean that these attorneys aren't still subject to the rules of professional conduct and the types of things that they can publicly say.
Cuber Forever here. Will this lifting of the non-dissemination order have a bearing on the ongoing investigation by a special prosecutor? That's interesting. And to who leaked information at Dateline? So I honestly don't know where that stands, Erin. I don't know if you do, but after that May 9th Dateline piece, Judge Hippler said, hey, I'm going to put together an investigation. I don't know if that was a threat or if he was actually moving forward with that, but you think that just goes by the wayside now?
If the judge actually did task somebody with looking into it, then this shouldn't really affect that. If they find out, who Dateline's source was while the non-dissemination order was still in place, they may still proceed with that, and there could be a contempt of court action that could arise out of that. So the lifting of this won't really have any effect on that. Whether or not the judge actually, like how much force he put behind that threat, we don't really know. So we don't really know how much work they're actually doing on it, whether the prosecutor's office is, has somebody looking into it, or if law enforcement is, or something, to try to figure out who leaked. It's kind of a non-issue at this point, yes, because it's been lifted. But at the same time, it depends on how upset the judge is that Dateline was obviously privy to inside information during that non-dissemination order.
Yeah, and that docuseries, I believe, is out on Amazon, which I have to check out. And I think James Patterson's book is out now. And those were some of the things that everyone was concerned about. From what I understand, there's not a whole lot of new information in there, but I've not seen the documentary. The state's position here, this was prior to the hearing today. They wrote in their filing, and they also expressed this at the last hearing, although they seem to back off of it. But Bill Thompson in the last hearing said, and I quote, "Given the history of this case, it would be best if the order, meaning the gag order, remains in place through sentencing so we can make sure there's the ability to completely answer questions." So he was framing it in terms of being able to answer questions. And Judge Hippler said, agreed at the time. He said, "I agree. We need more time to prepare for a quote unquote deluge of media requests, but those requests are coming no matter what." For the media outlets, it's all about freedom of the press, government transparency, what the public has the right to know, especially in a high-profile murder case. And that's why you had 24 different media outlets who had some sort of representation there today. They keeping in mind that the court wanted the right to a fair trial, but they want to balance that with the right to a free and open press. And that's why Judge Stephen Hippler at one point said, "Look, I was doing this to make sure that the jury would remain impartial, but now there is no jury, so I don't really have a reason to not lift the order." And therefore, he lifted the order, which is where we are at right now. Skye Lazaro, to you, one thing I would not want to do, which is what Judge Stephen Hippler says he has to personally do, is go through all these sealed documents now and decide what can be released and what can't. When he says that, does he mean like he literally has to sit at his desk and go through all these sealed documents? Or when you're a judge, can you just have your law clerk from the University of Idaho sit there till 4 a.m. going through that stuff, and then he looks at it? How does that work?
In a case like this, that better be him.
Yeah. So
Yeah. And really what he has in as far as sealed documents, I would think, or just anything that's been provided to the court. There may be things within the files of the discovery files that the court has never seen, that either wasn't going to be introduced as evidence or has never been disseminated beyond the discovery sharing process. So I would think all he has to go through is whatever's been submitted in terms of evidence in this case that's been before the court under an order to seal. And so he will have to go through those and decide what would be information that would be available, pursuant to some sort of request for public records, and what needs to be remain sealed and why they need to be sealed.
by the way, now that I do this podcast, when I'm at like 7-Eleven, I use the word pursuant with the person behind it. I'm like, pursuant to your store hours, can I still get such and such? I like using legal words like pursuant. So there you go. Mm-hmm. Charlie here, Barrow, not borrow. The judge sucks, but this show is smashing. Thank you very much. I have a feeling you're from the other side of the pond, because us Americans don't use the word smashing, but I love it. So What can we expect at sentencing? Erin, let's start with you. It's going to be on the 23rd. I believe the Chapin family, Ethan's family, has already said that they're spending the day out on a boat on a lake. They don't want to be there, which is their God-given and legal right to not be there. And I kind of respect the fact that they're doing that. But sentencing, Judge Hitler said, would likely take most of the day, if not go into a second day. Erin, what can we expect? How does it start? What does the judge say? Who gets to speak? Lay the groundwork for us.
And I will tell you that every judges are different. Even just in my district, every district judge will handle it slightly different. So I don't know how Judge Hitler is going to start. Some of them will start with the defendant, where they will get up and sort of make their argument. This is an interesting one because there's just so little argument to make, right? A lot of times there's a window, or you want somebody to get up to life, you want somebody to get 30 to life, and they want them to get five years, and so there's a window that you're actually arguing over. No one here is arguing, so there isn't going to be a lot for them to say. I think he expects it to take that long because of victim impact statements. So, I mean, in my time doing this, I had victims that didn't want to be present, didn't want to see the person, just didn't want to be in the room. But sometimes they would write something, or sometimes they would appear, but they didn't want to speak. They were too nervous to speak. And so they would write something. I've had people write 10 pages that they stood there in front of the microphone and read all 10 pages to the court. And it's sort of their moment. They get to get out everything that this has put them through, right? I mean, not just what it's going to put them through for the rest of their lives, but what this case and this litigation has done to them over the past 2 years. So, and it's so personal. It's such a personal thing. Like you said, the family that's just going to go out on a lake. They may write something. They may decide that they might regret it later if they don't at least get it put on the record, for the judge and for the public. I mean, the country, the world has really been riveted by this case, and it's so tragic. And so they may just want to be able to, and so in that case, I've read victim impact statements to the court. A lot of times we have a victim witness coordinator who works a lot with victims and stuff. Sometimes they'll read it. I've had people have a family member come in and say, I'm reading this on behalf of. So in a case like this, where all of these kids had families, and mom may want to make a statement, but dad may want to make a statement, or the twin may want to make a statement. I mean, there's so many, there's so many victims in this case. When you look at it, especially from a prosecutor's standpoint, the victim is the person that the crime happened to, or if they're deceased, then it's their immediate family. And they all have a right. They have a right to be heard. And I would think at this point that they've given the court some intimation of who they think or want to present victim impact statements to the court. I think that the biggest difference in this case, like I say, is that normally I go in there locked and loaded, ready to argue for whatever sentence I want. And then normally defense is ready to do the same thing. And sometimes our arguments can take 45 minutes to an hour each, just going through why I think this person needs to go to prison for this long, and why they're saying, oh, there's these mitigating factors. All of that's kind of removed in this case because everybody's accepted the fact that he's going to prison for the rest of his life. So there is none of those questions. So really, it's more just the presentation of the victims, their presentation to the court, which there again, it's really cathartic for them to be able to say whatever they need to say, because this is their one chance to do it, knowing that it's not, sometimes we do victim impact statements to try to sway the judge, to try to make him give them the maximum. They're not, for this, it's really a personal thing of them saying everything in this one opportunity to the bad guy that they want to say. And so it may be a day, just a day's worth of victims standing up and giving their victim impact statements. And then of course, the defendant has a chance to speak. Whether or not he will is, I guess right now, kind of the $1 million question on whether he'll speak.
Yeah, which is what I want to get to Skye about in 1 second. But Cynthia Sweezy here, Joel CEO and STS Stefan Stearns, his trial opening statements are set for a week from tomorrow. I'll be flying back on a red eye, so I will be here covering that from here. And then the following week, I'm going to go to the trial in Orlando. So it's a busy bunch of weeks coming up with STS. Boy, don't ever put my picture next to this dude again, CO. He just scared the crap out of me when I looked up. Sentencing 7/23/25. That's next week. I'll take you in an octagon, Bryan Kohberger. No doubt. He's actually a pretty big dude. Scary looking guy. But trust me, there are a lot scarier looking people at the Idaho Maximum Security Institution, which is where he's going. Skye, before I ask you about Kohberger and a possible allocution, let's say the Gonzalez family has been very outspoken. What if the mother, father, and sister all want to speak? Do they all have a right? The judge doesn't limit it to one family member, correct?
I would not expect this judge to limit it. Sometimes in certain cases, judges will make certain limitations if it gets a little out of hand. Under the victims' rights statute, though, these family members are all going to be considered victims, so they all have the right to be heard at sentencing. So I expect that he will allow anyone who wishes to speak that's within reason, a family member associated with the family, those types of individuals to be able to make a statement.
Yeah. And what's your gut tell you? And I'm going to ask Erin too, but Skye, first to you. Do you think we hear from Bryan Kohberger? Is he going to get up there and say something?
Looking at him, I mean, all I really can go on, he really hasn't said anything ever.
Yeah. Well, I mean, if you're advising him, which if this is your role as criminal defense, would you tell him, hey, Bryan, don't say anything, or keep it to one sentence? What advice would you give him?
You can apologize if he makes a statement, and I think this goes to you have to know your client. If he makes a statement and it is not a genuine, heartfelt statement, it's going to be worse than if he says nothing at all, in my opinion. If it comes across as, oh, and I'm sorry, or flippant, or I only took this deal because I didn't want him to kill me, or my lawyers told me to, or whatever it is, that's worse, I think, on victims' families, especially in cases like this. If it is not a genuine, I am taking responsibility, I'm a terrible person, I ruined your, I did this, I took the people you loved. If he's not able to do that in a very genuine way, I think it's just best that he says nothing.
Saying nothing at all is probably the best, but also if I'm the family, it's gonna drive me insane. But Brooke here, just supporting what I thought, which is he's in a prison sweatshirt. I don't want to keep showing this dude's face because it's scary, but there he is. That appears to be today. Appears to be in prison, or jail, I should say, jail clothing. But the focus should really be on the victims. What about you, Erin? The allocution, do you think he's going to get up there and suddenly apologize to the families? God forbid he says anything cruel, because I could see Steve Gonzalez diving over to try to get at him, which God forbid that happens. But do you think he says anything at all?
It's interesting. This is an interesting one because, like I said, defense and prosecution don't really need to argue. Everybody knows what you're getting. But because he's already getting the max he can get, right now that the death penalty is off the table, he's getting the max he can get. So he's kind of got nothing to lose. You kind of ask the question, what would you advise him? Well, who cares? He's spending the rest of his life in prison, and he really has nothing to lose. To think that he would apologize, I don't think he's sorry. I don't think he has any of those natural human emotions that we would expect. So I don't think he has that to offer. I don't know I think, I brought him up before, so I apologize for being repetitive, but Richard Allen Davis, who killed Polly Klaas in California, a long time ago, was one of the most horrific sentencings ever, because he used his one moment to speak to make a horrific allegation against Polly Klaas's father. And you talked about the Gonzalez father. I mean, Polly Klaas's father lunged at him and a group of people. And I was probably 19 when that happened. And I've never forgotten it. That video of that hearing, I've never forgotten it because it was so horrific. And and then you get, I think it's that moment where you go, okay, there's evil in the world. And that's the way I've always felt about Richard Allen Davis. Bryan Kohberger, I feel like he's evil. I feel like he's a different kind of psychopath. So does he have that urge in him to hurt somebody the way that Richard Allen Davis did? I don't know. I don't think so. He doesn't seem like that. He seems very stoic. If he plays, the good psychopath, then maybe, people will want to come and interview him. And I think he likes that attention. So if he went scorched earth on the family and tried to make tried to hurt them somehow, I think it limits, your people aren't necessarily going to write a book about you or come to prison and interview you, things like that. I think because of the way he's been so far, that whole, does he blink? He doesn't move. He's so incredibly still. I feel like all of his, whatever his psychosis, I feel like it's very internalized, that he keeps it really locked up. So I think there's a decent chance he doesn't say anything. And if he says anything like he's sorry, I think that everyone will feel the same lack of emotion in it that I just don't think he has that to offer.
Yeah. A couple of quick things. If you appreciate the content and our great guests, it's easy. Just hit that like button. You can subscribe. We've got a Patreon page. Also, we talk about morbid stuff nonstop. It's summertime. I have a book out by the same title. It's about my mom, who's a Holocaust survivor. It's funny, even though it's about the Holocaust, and she yells at me, and a lot of good life lessons. So if you want, check that out. It's available on Amazon. Do the guests think here, Skye, are there moments during these sentencing hearings where the families pivot and take out their frustration on the judge? There are people that have been frustrated a little bit with the judge. Is that something that we can expect to see? And Susie, thank you very much. I do have another birthday coming up if I make it. It's next Friday. It's a little premature, but thank you for this. What about that? What about going after the judge?
That will be interesting. I don't know how the victims' families feel about the judge in this case. I mean, he certainly has ruled in favor of the state at every juncture. So I'm not sure that they will necessarily go after the judge. I don't usually see that. If I see anything especially in this case, I think some of the families may express their frustration with the state in offering this plea just based on some of those statements they made initially. I see in cases a lot of times where victims and victims' families express frustration or displeased with plea agreements or offers that are made or things like that. And that often comes up in sentencing where there's something along those lines. I don't know that I would expect them in this case to go after the judge, but they may. But I would certainly expect someone to raise their frustration regarding the plea offer that was entered into.
One other programming note. I just got word tomorrow, 1 o'clock Eastern. This is very important to me personally. If you don't know the Ellen Greenberg story, please Google it. She was found dead in 2011 in a very nice suburb of Philly. She was living with her fiance. It was the eve of a huge nor'easter. She was in the middle of preparing a fruit salad. She's found dead with 20 stab wounds, 10 to the front of her body, 10 to the very back, with a giant gash on her head. Also with many, many bruises in different stages from what appeared to be domestic violence. And it was ruled a homicide. And then a couple of days later, switched to undetermined. And then after a shady closed door meeting, it was switched to a suicide. And just about 6, 7, 8 months ago, there was a civil lawsuit. On the eve of that civil lawsuit, the medical examiner said, no, it was not a suicide. He just put that down. Turns out that her fiance's uncle was a very powerful judge and defense attorney in Philadelphia, and has ties all the way up to Governor Josh Shapiro. So tomorrow, if you guys can join at 1:00, her parents are going to be here. They're going to update us on the case. Hard to believe, I know, but after this civil suit, Philadelphia has not paid them. The Greenbergs have spent $800,000 of their own money to investigate the case. They've never gotten paid, even though the city said that they were going to settle and pay. And they said or implied that they were going to start an investigation, and they never started an investigation. So if you guys can join tomorrow, it's one of the more important shows that we do. And then if you can put that out on social media and let the governor of the Commonwealth of PA, Josh Shapiro, know that we're not letting it go, I would appreciate it. Here's a petition right here. If you Google it, this story will make your blood boil. It appears that there's a killer who's just walking around 14 years. The case has never been investigated. So her parents are coming on tomorrow night. It's one of the biggest travesties of justice that I can recall. On the flip side here, these are the victims. This, by the way, I never really realized this because this is a photo everyone uses, but this was Kaylee Gonzalez's final Facebook post. And it was her talking about how lucky she is to have these friends, how lucky she is to be having graduated or about to graduate from the University of Idaho and go on to the next chapter of her life. And then that creepy glazed eyed killer took it all away from them. So gonna be a long week next week. We'll be there in court. We're gonna bring it to you live. I'm gonna try to get as much reaction as we can without harassing and hounding people. And I'm working on getting into the IMSI. I think you guys know that. We had the former deputy warden. That's the prison that Kohberger is going to. You guys know I'm deathly afraid of prisons, but I'm going to fight my fear. As I tell my kids, there's a book, Feel the Fear and Do It Anyway. And that's what I'm going to try to do. Tonight, Dan Markell, he is the FSU law professor, went to Harvard undergrad, Harvard Law School, and it was a murder for hire plot. His ex-mother-in-law, 75, is going on trial August 19th. Today is the memorial of his death on the Jewish calendar, which is what the Markells celebrate. And so we're just doing a roundtable show at 5:00 just to remember Dan, talk about some of the particulars of the case, but really just to remember a guy that was gunned down. Why the hell is there all this violence? What's the matter with this country? I don't know. In my next life, I'm going to have to stop doing true crime and like review cartoons or something. It's starting to get to me, but love you all. Love you, America. Love you. Thank you, Skye, Erin. Love you, Utah. Love you, Pocatello, Idaho, Boise, Idaho. And it looks like we're getting justice. 329 away from 150,000 subs. We've been going at it day in, day out. So if there are 329 people out there who want to put their DNA on that sub button, that will be a nice milestone to head out to Boise with. But thank you to everybody, especially Skye, who jumps on for us when we're in desperate need. COE, I'm afraid to hit the end button. Something's going on with the software where it never really ends. And then Skye, Erin, and I will be talking about all of you, and we will not know that we're still on, and then we'll get in trouble. So I can hit end. I don't see end, but I will hit end right here. Let's see if this works. Thanks, everybody. See you tomorrow. No, see you today, 5:00 Eastern.